All right, good afternoon. We are now on the record and video streaming in this matter, so I will call the evidentiary hearing to order. My name is Andrew French. I'm chair of the Kansas Corporation Commission, serving as presiding officer for this hearing, and I'm joined by my colleague, Commissioner Annie Keither, for this hearing. This is docket number 25 CONS 3331 CPEN, captioned in the matter of the failure of BG5 Inc. operator to comply with K.A.R. 823-111 at 65 Wells in Franklin County, Kansas. And we will begin with the entries of appearance. We will start with commission staff.
Thank you. Tristan Kimbrell on behalf of commission staff and the public generally.
And for BG5 operator.
Operator appears by its attorney, Keith Brock, and also by its president, Scott Berkdahl.
All right. Thank you. Good afternoon, Mr. Brock.
Good afternoon.
We will now move to notice of this hearing. Does staff have a recommendation on notice?
Yes, notice of this hearing was contained in the presiding officer order setting this evidentiary hearing filed on October 31st, 2025. The order was properly served on all parties, and staff notes that all parties are in attendance today. Based on these facts, staff recommends the commission find that notice is proper and that the commission has jurisdiction to hear this matter at this place and time.
Any objection?
No objections.
All right, hearing no objection to notice, and based on staff's recommendation, I will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Let's start with a few preliminary matters, just some logistics, our normal disclaimers on technology, and then we'll discuss the procedure for the hearing. Some of those initial things. First, we are conducting this over Zoom. Sometimes things can go wrong. If any party encounters a technical issue, just please ask us to go off the record. We can take a brief recess, resolve that issue, and then we'll go back on the record. Second, witnesses are asked to keep their microphones off or muted when they're not scheduled to talk. If everyone would mute your cell phones, phones in your offices, other electronic devices, that would be appreciated. Third, just so the parties are aware, if the commissioners need to consult among ourselves for something like an evidentiary ruling, we'll go off the record and enter into what's called a Zoom breakout room to discuss, and then we'll return and come back on the record. Fourth and finally, just please be very careful to identify exactly what you're referring to when we're discussing pre-filed testimony or exhibits. The commissioners, all the parties should have copies of everything on hand, so we should be okay to follow along as long as the documents are properly identified. With that, just pause briefly to see if there is anything, any other preliminary matters the parties wish to take up before we begin the proceeding.
Not from staff.
None from operator.
Okay, thank you. All right, regarding procedure for the hearing, parties will be allowed to make opening statements. After opening statements, we will have the examination of witnesses. After direct examination of each witness, there will be an opportunity for cross-examination and commissioner questions and redirect. Any further examination by the parties or commissioners would just be at the discretion of myself at that point. Following witness examination, we will allow closing statements and arrange for the filing of post-hearing briefs if that's necessary, and then we will conclude the hearing. So as I just mentioned, we will begin with opening statements, and I have staff listed to go first. Mr. Kimbrell.
Thank you. Commissioners, this docket concerns responsibility and not being able to simply wash one's hands of responsibility when it becomes convenient. As the evidence this afternoon will show, BG5 added all the Jackman and Wright wells that issued in this docket to its operated well inventory in 2010-2011. The form BG5 used has operator well inventory written in bold at the top and Mr. Berkdahl's signature below. Mr. Berkdahl will likely argue that he was told to put the wells on the inventory by commission staff, even though he wasn't taking responsibility for the wells, but Craig Stoll will testify that he is not aware of staff ever telling an operator to place wells on his inventory if the operator wasn't responsible for those wells. Additionally, in the letter that Mr. Berkdahl included with BG5's 2010 well inventory, he didn't make any mention of not taking responsibility for the subject wells. Mr. Berkdahl may further argue that since he didn't write a date on the year assumed responsibility line next to the wells on the well inventory, that BG5 wasn't actually taking responsibility for the wells, but that's not supported by the evidence. In the letter he sent with the 2010 inventory, Mr. Berkdahl wrote that the date he put as the year assumed responsibility next to wells was the year the well was placed into production, not the year BG5 assumed responsibility. Just because the wells at issue in this docket didn't have a number next to the year assumed responsibility doesn't mean that he wasn't taking responsibility. It just means they hadn't been placed into production yet. So ultimately, BG5 intentionally typed the Jackman and Wright wells onto its well inventory. Mr. Berkdahl signed his name, and BG5 wanted those wells on its inventory. It was purposefully done. Even more important is the fact that every year from 2012 through 2020, BG5 certified in Kohler that it was responsible for the Jackman and Wright wells. There was no attempt by BG5 to remove the wells from its inventory or put in notes saying that it wasn't responsible for the Jackman and Wright wells. And I think it's helpful to look specifically at the year 2016. In 2016, BG5 received a notice of violation letter from commission staff because the subject wells were inactive. BG5's attorney, Keith Brock, sent a letter to staff in response, and that letter is included as an attachment to Mr. Berkdahl's pre-filed testimony. In the letter, Mr. Brock notes that BG5 received the NOV letter from staff and states that BG5 is, quote, actively investigating the history, location, and current status of the wells. The letter doesn't say anything about BG5 not being responsible for the wells. If BG5 had purposefully never taken responsibility for the Jackman and Wright wells, why the need to investigate the history of the wells? Wouldn't the letter have just simply stated BG5 wasn't responsible? Instead, Mr. Brock's letter asked for more time to determine the current status of the wells. And after the letter was sent by Mr. Brock in 2016, BG5 continued to certify its well inventory in 2017, 2018, 2019, 2020, with no mention that it wasn't responsible for the subject wells. It was only in 2021 that BG5 first claimed in Kohler that it wasn't responsible for the Jackman and Wright wells. Only in 2021, 11 years after placing the wells on its well inventory, did BG5 first claim it wasn't responsible. And so, commissioners, I hope you'll ask yourself, if a state agency told you that you were responsible for a costly piece of property and you didn't think you were responsible, wouldn't you be raising a ruckus? Wouldn't you be making sure everyone knew you weren't responsible? Would you really wait 11 years to say anything? And not only wait 11 years, but for 11 straight years certify that you were in fact responsible for that property? I don't think anyone would do that. And the same is true here. BG5 claimed responsibility for the Jackman and Wright wells because it was responsible and never claimed otherwise until only a few years ago. One important point I want to make about language. Throughout this hearing, Mr. Brock will likely refer to the subject wells as abandoned wells. And I ask that you notice every time he does that. KSA 55-179 has a very helpful definition of an abandoned well. It states that an abandoned well is a well that is not claimed on an operator's license that is active with the commission. The Jackman and Wright wells are on BG5's license, and BG5 is active with the commission. The wells at issue in this docket are not abandoned wells, and the commission should not consider them to be abandoned wells. Staff is aware that this docket concerns 65 wells, and 65 wells, that's a lot of wells to bring into compliance. So if the commission determines that BG5 is responsible for the Jackman and Wright wells, staff would be supportive of an order allowing BG5 to add those 65 wells to the compliance agreement it currently has in place with staff. But no matter how the wells are brought into compliance, they are BG5's responsibility. BG5 took responsibility for the wells over and over and over and over again, year after year, and staff asks that the commission find BG5 responsible for the subject wells, affirm the penalty order, and not let BG5 simply wash its hands of its responsibility. Thank you.
Thank you, Mr. Kimbrell. Mr. Brock, your opening.
Yeah, thank you. Well, it appears that one of the issues that we had raised may be resolved. We had contended that this shouldn't be brought forth as a penalty docket because it wouldn't serve anyone's interest to penalize BG5 for simply contending that it wasn't responsible for these wells. As staff noted, the whole crux of this docket is whether or not BG5 is legally responsible for these wells or not. The reason that temporary abandonment applications weren't filed is because BG5 would have legally accepted responsibility for the wells by doing that. And so we would ask that no matter how this docket comes out, that there should be no monetary penalty issued. This is really an issue about well responsibility. As it relates to the wells themselves, The facts are not disputed that BG5 never operated these wells. BG5 never profited from them, never produced them, never filed any documents with the commission concerning these wells. It's also undisputed that when BG5 submitted its T1s listing the wells on the Jackman and the Wright leases that it assumed responsibility for, these wells were not included. They were specifically omitted. It's also clear that in 2010, the commission went about trying to compile a database of a list of all the wells located in the state of Kansas in order to help them better regulate. As part of that process, they were promising operators that if they would come forward and report abandoned wells, that they wouldn't be held responsible. As part of that process, the commission began requiring well inventories to be submitted. When that was done in 2010, that first year, there were no regulations that specified what that well inventory was, how to fill it out, or anything else. There are no statutes that would explain what that is, how to fill it out, or anything else. And so that was rolled out alphabetically. Operators that had for example, BG5, since it started with a B, it was among the first operators to be required to file. BG5's president called the KCC staff, asked questions over a lengthy period of time about how to fill out this form. They disclosed the fact that, hey, there are these abandoned wells on these two leases that you guys have no records about. The KCC was not aware that these wells existed either. BG5 wasn't aware that they existed until they went out looking for them, and Mr. Berkdahl actually located them in the field. So he explained this to the KCC staff, told them about the wells, and basically was told that, yes, we need to have these reported in some way so that they can go into our database, but we understand you don't want to accept responsibility. And so he was instructed to list them on his well inventory, but to not complete any year assumed responsibility. In essence, they were listed, but he didn't assume responsibility for the wells on that filing. He did exactly as he was told to. At some point later, Conservation Division staff modified his well inventory form, and they did not notify him that it was modified. He certainly never consented in writing to these modifications, and that's how they came to be added onto to the BG5's well inventory. And KSA 55-179 specifically addresses this. There's language in that statute that specifically talks about modifications to a well inventory made by commission staff. And it says that any modifications don't alter well responsibility unless you notify the operator of the change and they consent to it in writing. In essence, an operator is not required to fly spec their well inventory every year to see if staff changed something and to catch it. No operators put under that burden, and the statute contemplates that. There's a lot of testimony from staff about the effect of a certification, the effect of a well inventory. These are their opinions, but that is not the law. The law does not support what they're arguing, and the majority of this case is a legal question. And so accordingly, we just ask the commission to follow the law. This isn't an equitable case. This isn't fairness. This is, what does the law say? Who is responsible for these wells? And if the law does not clearly provide that BG5 is responsible for these wells, then they aren't. So I have nothing further.
All right, thank you, Mr. Brock. We will now move to the examination of witnesses, and we will begin with staff. Mr. Kimbrell, you may call your first witness.
Thank you. Staff calls Craig Stoll.
All right, good afternoon, Mr. Stoll.
Good afternoon.
I'm going to have you please raise your right hand for me.
Okay.
Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. Please proceed, Mr. Kimbrell.
Thanks. Mr. Stoll, could you please state your full name for the record?
It's going to be Craig Stoll.
Are you the same Craig Stoll who caused to be filed in this docket direct testimony consisting of 6 pages and 6 exhibits, and rebuttal testimony consisting of 6 pages?
Yes.
Do you swear that the answers contained in your pre-filed testimonies were and are true to the best of your knowledge?
Yes.
At this time, I move for the admission of Craig Stoll's pre-filed direct testimony and attached exhibits and pre-filed rebuttal testimony to the formal record.
Any objection?
No objections.
Hearing no objection, both of the referenced testimonies and exhibits will be admitted.
Thank you. I tender the witness for cross-examination.
All right. Mr. Brock, any cross-examination for this witness?
Yes, thank you, Mr. Chairman. Mr. Stoll, in your pre-filed testimony, it says that you were an environmental scientist with the KCC from July 2012 until April 2022. Can you just generally tell me what that position entailed?
That position was brought on to process land spreading applications and to do research in our library. Ultimately, then I did gain some responsibility with doing well inventory certifications as I kind of learned the KCC system late into 2012 and 2013.
And then in 2022, you changed positions, and what does that position entail?
It is going to be the supervisor of the Environmental Protection and Remediation Department. So I oversee the practices and the functions of this department.
Mr. Stoll, in your testimony, you talk about basically the effect of an operator certifying its well inventory and the effect of a well being included on an operator's well inventory in terms of whether or not they're legally responsible for a well. Can you tell me what law you're basing that opinion on?
I don't know that. To go to the law, that would be, a legal question.
But I mean, you've indicated that the well certification has certain legal implications. But are you saying you don't know what the law is that creates those legal implications?
I do not.
And you also said that listing a well on an operator's well inventory creates certain legal implications. Are you also saying you don't know what the law is that creates those legal implications?
I do not.
And so would you also agree then that if you're incorrect about what the law provides in those areas, your opinion about whether or not BG5 should be legally responsible in this docket would be incorrect as well? Do you agree with that?
I don't know. I would refer that to the legal department.
So I guess ask the question another way. Your testimony in this docket is dependent entirely on your understanding of what the law provides. And if that understanding is incorrect, then your opinion may be incorrect as well. Is that correct? Do you agree with that statement?
My understanding of the certification process would be is how it came in on paper and how was it processed internally. To what law that goes to, I don't know.
Commissioner, if I could share my screen, Mr. Chairman.
Yes, you may.
Are you seeing 82.3.120?
Yes, we see it.
Okay. I always worry I'm sharing the wrong screen and and it's not up there. So Mr. Stoll, this is KCC regulation 82.3.120. It deals with operator contractor license applications. Are you familiar at all with this regulation?
To some extent, but not fully, no.
If I represented to you that this is the regulation the only regulation that contains any provisions concerning a well inventory, would you have any reason to dispute that?
I'm going to object at this point. I mean, I believe Mr. Stoll has already testified that he's not an attorney, that these are legal questions. I think this could be brought up in briefing after the conclusion of this hearing.
Yeah, I'll sustain it, to the exact question asked. If you'd like to take Mr. Stoll through any specific language here and ask him about it, I would allow that. But yes, anything, assuming something that's not in the actual words here would probably go too far.
Okay. Mr. Stoll, there's a highlighted portion at subsection F. Can you see that on your screen?
Yes, I can.
If you could take a minute to read that, do you believe that that language is speaking to the well inventory requirement that you talk about in your testimony?
I would say so, yes.
And do you see this part above my cursor where it basically provides that an operator is only required to provide a well inventory if they're seeking financial assurance under 55 D1, KSA 55-155 D1. And in that instance, they can either furnish the well inventory or required to post the $45,000 bond. Does that seem accurate to you?
Yes, I do see that in the regulation.
And would you agree that because BG5 had an acceptable record of compliance for 3 years before 2010, it was not pledging financial assurance under 55-155 D1?
The financial aspect of that with financial assurance, that would be something with our licensing department. That's something I don't regularly look at.
Okay. So this is KSA 55-155, and if we scroll down to D1, it talks about a bonding requirement equal to 75 cents times the total aggregate number of wells. You see where that's highlighted?
I do.
And then if you look under subsection 3, there's also an option that an operator who has an acceptable record of compliance basically doesn't have to do that. They just pay a non-refundable $100 per year fee. Do you agree with that?
I do see that, yes.
Okay. And so can you identify what this document is that I've displayed to you?
From the top header of that would be the license renewal application.
Would that be for BG5 in 2010?
Yes, the license number looks correct and the expiration date of 2010 looks accurate as well. So yes.
So if we scroll down to item 10, it basically specifies in that highlighted area, I'm sorry, the area that I had clicked with my cursor, what BG5 was obligated to pledge for financial assurance. Do you see that?
Yes, I do.
And so what did they pay that year?
They paid the $100.
And so I would move for the admission of this BG5 license renewal docket as a rebuttal exhibit.
I'm going to object at this point. This is something that Mr. Brock did not send to me beforehand. Under K.A.R. 82.1.221, we have a specific regulation that states that unless otherwise directed by the commission, an original 7 copies of an exhibit must be offered into evidence other than rebuttal shall be filed with the commission at least 10 days before the date of the hearing, and 1 copy sent to each party. This is not rebuttal. This is cross-examination. Mr. Brock did not give this exhibit to me beforehand, and I think it's inappropriate to be trying to ambush staff at this point in time.
Our response would be that in 82.1-221, it specifically says about 3 times other than rebuttal testimony. So in essence, if there is rebuttal evidence, it doesn't have to be provided ahead of time. This document was provided to staff in the form of a discovery response, so they did have it. It's not a surprise that it existed. It's just a surprise that we were going to use it. This was brought about by information contained in Mr. Stoll's rebuttal testimony.
And I would just respond that if this is rebuttal, then it should be done during Mr. Berkdahl's testimony, not during Craig Stoll's cross-examination.
All right. I'm not thrilled about how late it came, but it does appear to be a record of the KCC. And so I think we can take notice of it. Mr. Brock, could I please have you proffer the relevance of it, though? I think I can guess, but if you would go ahead and lay that out for me before we admit it.
Yes, Mr. Chairman, I've not done a proffer before the commission. Do you want me to do that through question and answer with the witness, or?
I'm okay if you just want to explain to me the meaning of this document, the point that you're trying to get across to us.
Will do for sure. So KSA 55-155 subsection D1 talks about basically an operator being required to post a bond. There's also subsection D3 that allows them to pay a $100 per year non-refundable fee, which is exactly what BG5 did. If you go back to the well inventory requirement in 82.3.120, it's clear that this KSA 55-155D1 is not applicable to BG5 in 2010, and therefore it wasn't even required to file a well inventory.
All right. I think you could probably lay it out further, but I think I get it. One quick question, Mr. Brock and Mr. Kimbrell. I'm not a Kohler whiz. I'm assuming this exhibit is available either on Kohler or elsewhere within our records. Can someone confirm that?
Well, I'm not sure that it's available in Kohler. I haven't seen it before.
Would it be available in other commission records?
I'm afraid I'd have to talk to the licensing department about that. I would assume so.
I think Mr. Brock mentioned that this was produced in Discovery. Was it produced by BG5?
Yes.
Or was it produced by staff? Okay.
No, BG5 produced it. I don't recall if we got this originally through an open records request from the commission, or like I don't remember. I don't recall.
Why don't we
we
just
did
take
produce
your motion under advisement for right now, to the extent the parties can confirm this is in the commission's files and records. It looks to be an official copy, but let's get that confirmed. I'll just put that on the list of action items for John Myers to follow up with you all. And to the extent we can confirm it's part of the commission's files and records, then we will take notice of it.
Mr. Chairman, I did not mark this document in any form. I don't know if you, I'm not sure if you want me to, or if you want to designate it, but I did not do that.
Let's designate it BG5 Hearing Exhibit 1. Is that okay?
Yes.
And Mr. Myers, well, actually, I think what we'll do is we can just clean that up whenever we issue an order in this. We'll tell you whether it was in or out, but I'll have Mr. Myers get with the parties to make sure we understand the foundation. All right, you may proceed, Mr. Brock.
Thank you. Okay, Mr. Stoll, I'm just going to skip right to it. We've went through the other statutes and BG5's license renewal. So would you agree that under subsection F of 82.3-120, since BG5 was not furnishing financial assurance under KSA 55-155D1, this subsection would not even have required BG5 to submit a well inventory with its license renewal application?
It would seem to me that would be kind of an or statement. They were able to do their assurance and they supplied the well inventory as well. So they did both of them.
But you would agree they are not required to file a well inventory?
The way that I read it is, yes, they didn't have to, but they did.
Okay. And I can scroll up or down in this regulation if you'd like for me to, but do you see anything in there that would state that an operator becomes responsible for a well by virtue of it being listed on a well inventory form that may be filed under this subsection?
I don't see it saying responsibility in there, no.
Do you see anything listed in here? And again, I can scroll up and down if you need me to, but do you see anything in here that talks about an operator being required to certify annually a well inventory?
In that one, I do not see that it says that they need to supply it annually, but looking at that one sentence to the prior question, if I may, but when it says they shall also furnish a complete inventory of wells and the depth of each well for which the operator is responsible. So if you're filing that and you're putting that on the form, which was the OWI-1, right there, it says the operator is responsible. So if you furnished, in my opinion, if you furnished the inventory, that was showing that you were responsible.
And so the result, though, of there being a mistake on the inventory, what does the last sentence say is the result of a mistake on the inventory?
Falsification of that, yeah, would be the $5,000 penalty.
A monetary penalty, correct?
Yes.
And so since we don't see any reference to certifying an operator's well inventory, I take it then that there is no reference that an operator can become responsible for a well simply by certifying a well inventory in this either?
Can you
I'm
rephrase
going to
that?
object. I'm going to object. I mean,
I,
Mr. Brock is asking Mr. Stoll to make a legal conclusion.
I think I went one too far, Mr. Chairman.
I
I
I
would.
appreciate that, Mr. Brock. I was about to say, I think, the regulations say what they say, and if parties want to make an argument about that, that's fair, but I don't know about the value of asking witnesses much more about the regulation itself.
Understood, Your Honor. I'm ready to move on. Like I say, I think I asked one. I should have stopped at one earlier. Mr. Stoll, in your pre-filed rebuttal testimony, I'm looking at page 3, lines 1 through 3.
Say page 3.
Page
Okay.
3, it's your rebuttal testimony, page 3, lines 1 through 3.
Okay.
I have it on the screen if that's easier for you too.
So yep, I see the lines 1 through 3. Yes.
Okay, the sentence that I'm specifically looking at, or there's two sentences, but it would be these highlighted sentences. So it would be the only two full sentences. It starts with the entire reason for a well inventory is to determine the wells for which a particular operator is responsible. Staff telling an operator to place wells on its inventory, even though the operator was not responsible for those wells, makes absolutely no sense. Do you still believe that that statement is true?
Yes, I do.
And what's the basis for that opinion that the entire reason for the well inventory is to determine whether an operator is responsible?
Because when the well inventory certification process started, is we're trying to build a database and find out what all the operators, had responsibility or owned. Ultimately, that was the start of the inventory process, was trying to get a better picture of, what everybody, operated. It is not, to my knowledge, of the staff ever telling anybody to add a well to an OWI-1 or add it to Kohler. Even if they, were not the responsible party. I mean, I have not seen that in my career here. So I stand with those sentences.
Mr. Stoll, I've displayed on my screen part of a publication by the Independent Oil and Gas Service Association from Wichita, and it's talking about the rollout.
I'm going to object. I have not seen this. Raise the same objection that under 82.1.221, this should have been provided 10 days ago. This is not rebuttal. This is cross-examination. It should not be allowed.
I think this one is impeachment testimony for his statement in his rebuttal testimony. It goes directly to what he said about the purpose of this regulation and what it does, and is intended to basically refute that.
And Mr. Brock could have supplied that 10 days ago. He's only doing it now to ambush a witness.
Can you identify again what this is and where it's from, Mr.
It's
Brock?
from so the Independent Oil and Gas Service, Inc. is a news publication out of Wichita. They publish oil and gas news. This is part of that publication, basically preceding the January 1, 2010 rollout of the well inventory process.
Well, I understand the objection, but I will go ahead, Mr. Brock. You may ask the witness questions about this document. I don't know if we'll get it into evidence, but you may certainly ask the witness questions about it.
So thank you, Mr. Chairman. Mr. Stoll, the part that I'm wanting to direct your attention to is the second paragraph. The purpose of the well inventory is to gather comprehensive and timely data to populate the KCC database that will assist the KCC in regulating the oil and gas industry and providing effective service to both the industry and the public. The KCC is authorized and has a duty to collect this data pursuant to 55-155. Does it appear to you that that's speaking directly to the purpose of the well inventory?
I would say yes to an extent, but I don't know fully. I haven't been able to review this document.
Understood. That's fair. I guess I'll ask if you were incorrect in what the purpose of the well inventory was, if it is to collect data for the commission's database to identify all wells in the state rather than to assign responsibility, would that change your position concerning BG5's responsibility for the wells at issue in this docket?
I would still, the well inventory process is done by each operator. The way that I'm kind of understanding from your side is that basically the whole KCC database, the well inventory was to go specific at the individual operators. So the operator would submit on the well inventory what they was responsible for, what inventory, what wells they had. So I would still stand by that, saying that that two sentences from the previous rebuttal.
And so just, I'm not going to necessarily ask you a question, but I'm just going to point out that this is referring to the statutory authority being 55-165, and then I'm going to show you another exhibit. So this is frequently asked questions that exists on the commission's website concerning well inventories. Are you familiar with this?
I've seen this before, but it has been very, very many years ago.
I would ask the commission to take notice of this one, being that it is the commission's information that it publishes.
Is there any objection to taking notice of the KCC's website?
No objection to this one.
All right, we will we'll admit this as BG5 hearing exhibit 2.
So I'm going to direct your attention to question number 2. What is the purpose of the well inventory? And then it specifies again what the exact purpose of the well inventory is. It appears to me that that's talking about creating a database for the commission to regulate the oil and gas industry. Do you see any reference in that answer about the purpose being to assign responsibility to individual operators?
It doesn't say that per se, no, but ultimately the well inventory process, was done by individual operators. They were giving us the information that they had. Nowhere in there does it say that they had to compile and send in information for other wells that are out in the area that they have no responsibility for.
And so in your rebuttal testimony and stating that the entire reason for the well inventory is to determine which well a particular operator is responsible for, you did not take that from this source or another source from the commission. Would that be accurate?
It did not come from this document, no.
It's just your personal opinion?
Yes, it would be my opinion and my years of experience.
And again, this question relates to 55-165. I'm going to display that statute for you just so that we can see what that says. So this is KSA 55-165, and it says the State Corporation Commission shall create and maintain a database of all oil and gas wells in existence in this state. The database shall include the location of each well, name, address, other information relevant to identify to the identity of the operator of the well. It appears to me that this is talking about a database for all wells in the state of Kansas, both those claimed by operators and those that are not. Would you agree?
I would say that, yeah, it's referring to overall database, but identifying it with the operator as well.
And do you see in here that it talks about an operator becoming responsible for a well simply by listing it on this well inventory form?
It does not state that in there, no.
I've switched back to the frequently asked questions that's been admitted as BG hearing exhibit number 2. If we scroll down to question number 8, so this appears to be talking about the regulation, the 82.3.120, that a well inventory is only required for financial assurance purposes. And it says, I'm in good standing with the KCC. Why am I subject to this new requirement? And then the answer is all operators are subject to this requirement regardless of standing with the KCC. The commission wishes to verify and update all well information in the KCC database to ensure the KCC is able to continue to effectively provide quality service to the industry and the public. In that answer, does it appear to you to indicate that the purpose of the well inventory is to create liability on behalf of an operator for a well?
Ultimately, with the inventory, it's one of those things is, yeah, it creates, some responsibility because the operator is telling us what they have, but and then with the operator telling us what they have with the characteristics, location, certain things that are, given on the OWI-1, it does overall helps the KCC database. It does help it, be more quality service to the industry and the public. So I think the inventory does help with that.
I mean, the reason that I asked the question is Mr. Bergdahl testified that the KCC was holding out that they wanted to locate all wells in the state of Kansas at the time that these well inventories were being required. Your testimony is that the only purpose was to assign responsibility to individual operators. I guess my question is, do you think that these answers to these questions still support your statement that the entire reason for these well inventories is to assign well responsibility to particular operators?
That's one aspect of it. I mean, the well inventory, I mean, it gave us so much new data that we didn't have. We were able to perform research in our library, use our resources to overall make a better database. Does, creating responsibility, I mean, and gives that to operators when they claimed it on the inventory, does that happen? And did it? Yes.
Would you agree that this requirement to file a well inventory was brought about after the issuance of the Quest decision? Do you know what I'm referring to when I would say Quest decision?
I have heard of it, but I do not know about it. So I do not know.
I'm not asking you to look at any order, but just for clarity of the record, I'm referring to KCC docket 07 CONS 155 CSHCO. That's not a question. I thought for clarity of the record, I should identify it by docket. So when you say you've heard of it, did the Quest decision create a major policy shift at the commission with regard to its stance on operator responsibility for wells?
Objection. Mr. Soul just stated that he's only heard of it. He's not familiar with it. And again, this is a legal question.
If he doesn't know, I'd be satisfied with he doesn't know, but I mean, he leads that department. I suspect he probably knows whether it did or not.
I missed your exact wording of the question. Can you just restate the question, Mr. Brock?
I just asked him if he if the Quest decision basically marked a major policy shift at the commission concerning operator responsibility for certain wells.
I'll let the witness answer to the extent he has personal knowledge.
I don't know in regards to that. That was before my time. So I would not be knowledgeable in that.
So would then the reason for requiring the well inventory forms to be filed, it seems like that would be before your time as well, is it?
I began employment with the KCC in 2012, July to be specific. So if this preceded that, then yes, it was.
Okay. Okay, just a couple more and then I'll wrap it up. So one final question. Concerning the right lease, which is one of the leases at issue in this docket, or when I say the right lease generally, are we tracking, understanding the same? Are you
Yes.
understanding what I'm referring to?
Yes.
Okay. And so on the right lease, some of the wells that are at issue in this docket were located on the right lease, correct?
Yes.
And would you agree that for the wells that are at issue in this docket, where BG5 did not indicate that it assumed responsibility in a certain year on that 2010 well inventory? I'm sorry, that was a long question. I forgot how I started it before I got done. If you'd let me just rephrase it. So when BG5 submitted its 2010 well inventory pertaining to the right lease specifically, do you recall that they did not complete a year assumed responsibility for the wells that are at issue in this docket on the right lease?
I do believe the responsible was left blank.
Okay. And then in your testimony, you talk about a subsequently filed T1 operator transfer form. If I'm going to summarize, it appeared that when BG5 submitted its well inventory, that staff recognized a T1 had never been filed for the right lease and required that a T1 be filed. Does that seem accurate to you?
Yes.
And that T1 was filed in early 2011. Do you agree with that?
Yes.
And would you also agree that that T1 did not include the wells, the right wells that are at issue in this exhibit, and that that T1 was accepted by Conservation Division staff?
Yes.
Okay. I'm going to ask the question generally and try to, well, I'm going to refer you to your testimony just so you don't think I'm trying to trick you. But this is in your rebuttal testimony at the bottom of page 4. And the question's more generally, but as I understand what you're saying in this answer is that if operators were not held responsible for wells simply because they left the year assumed responsibility blank, it would create this whole host of other wells that nobody would be responsible for. Is that what you're saying? I guess your word is rash of other operators.
So in regards to that one, I mean, if you're looking at the inventory itself, and I've never seen another instance where an operator is going to put additional wells on the OWI-1 that they're not responsible for. And then there's no indications on any of that submission that just says, hey, I'm doing this out of the kindness of my heart. I'm, doing this. This is not part of it. It was submitted on that form itself, which indicates to staff that that is part of their well inventory.
So in this situation, the facts are that BG5 did not accept a T1 for the wells at issue in this docket, and they filed a well inventory that did not have that field completed where the well responsibility was accepted. Do you agree that those are two pertinent elements in this case?
Yes.
Can you list for me a single operator, a single well, a single lease where those facts would also be present?
I can't.
Thank you. I have no further questions.
All right, thank you, Mr. Brock. We will move to commissioner questions. Commissioner Keither, do you have any questions? Oh, and Mr. Brock, you can take down the share screen, I believe.
Oh, sorry about that. I forgot.
All right, Commissioner Keither, no questions? I believe I may have a couple. Good afternoon, Mr. Stoll.
Good afternoon.
First, I think a simple one that you are either going to know or not know, but referencing your direct testimony, I think your first exhibit, you had a screenshot of sort of the attestation language that's included when an operator signs their well inventory.
Yes.
It looked like that was 2025 language. Do you know if that language, can you personally say whether that language has basically been consistent throughout the years, or was it materially different 5 or 10 years ago? Do you have any knowledge of that?
I do not. I do not recall of any edits that have happened to the vocabulary or the wordage on that page that shows up on their certification. I have not seen anything come through my desk that there's been any changes to it.
Okay. I might ask Mr. Russell if he knows anything about that, and it may be something we could get a after hearing exhibit or admission from staff on as well. So just out of curiosity, I don't have any reason to believe it's not the same, but I noticed that was 2025 language. So the other thing I hesitate to even ask you about this because maybe it's a legal question, and your counsel can object to me if he needs to. It seems like you and Mr. Brock were playing a little semantics on your rebuttal testimony, particularly the lines where I believe your words were that the reason for an inventory is to determine responsibility for certain wells. I think Mr. Brock's words were to assign or create responsibility for wells. And I'm sitting here thinking those sound like different things. It sounds to me like one of you is saying that this inventory is the document that makes somebody responsible. The other one is saying the inventory is the thing that documents that somebody is responsible. Is that a distinction staff would make? Is this document the thing that actually creates the legal liability, or is it just the thing that's documenting that somebody is responsible? And if that's a question for your attorney, then you can, I'll just preemptively say you can turn it to him.
I think that question would be better handled in the department.
I had a feeling as I was going down that path, that's what the answer was going to be. Do you know, and maybe you're not the right person to ask this, and this might be for legal counsel or it may be for Mr. Russell, but if we didn't have an inventory associated or a well on somebody's inventory, and we've maybe had some hearings lately where this was the case, would there still be a process to determine, or could someone still theoretically, an operator still theoretically be found responsible for a well, even if they didn't list it on their inventory?
That might be a good question for district staff.
All right, sounds good. I'll skip those then. I think that's actually all I had with those final legal questions, so we'll just keep those on the list. Since Commissioner Keither did not have any questions, I believe at this time we are ready for redirect from Mr. Kimbrell. You may proceed.
Yeah, I just had a couple of questions. And Mr. Brock, if you wouldn't mind pulling up that frequently asked questions document again, since I don't have a copy of it.
Oop, which
Sorry,
one did you want?
The frequently asked questions one.
Yep, give me 1 second.
If you go to question 2. Thank you. So Mr. Stoll, Mr. Brock was asking you about question 2 and said that the purpose of the well inventory is to populate the KCC database with well information that is complete, correct, and current. Is the operator responsible for, is the operator who is responsible for a well important to make sure that the KCC database is complete, correct, and current?
Yes.
Okay. And if we could go down to number 8, Mr. Brock, question 8. And again, Mr. Brock brought up this question, and he read that the commission wishes to verify and update all well information in the KCC database. Is the operator who is responsible for well information that needs to be verified in the KCC database, Mr. Stoll?
Can you repeat that one more time, please?
Sure. So the frequently asked question, it says in that second sentence, the commission wishes to verify and update all well information in the KCC database. So is the operator of a particular well information that would need to be verified by the KCC?
Yes, we do use our resources that we do have in-house and resources online to verify the information, yes.
And is the operator who is responsible for well, is that important information that needs to be in the KCC database?
Yes, very much so.
Okay, you can take that down now, Mr. Brock. Thank you. And then Mr. Brock asked some questions about whether BG5 was required to submit an inventory. I just want to make sure that BG5 voluntarily submitted this inventory. Is that correct?
Yes.
Okay. I have no further questions at this time. Thank you.
All right. Let's see. Mr. Brock, I'm assuming no recross is necessary since the questioning was pretty light there, or do you have a brief follow-up?
I just have one, just from the very last question. I'm going to share my screen again. So I'm showing you the frequently asked questions, the BG5 hearing exhibit number 2. On item 3, what is that? I mean, does that seem to indicate that it's voluntary for an operator to file a well inventory?
I would make it a requirement.
And then item 7, doesn't it appear to indicate that staff isn't going to process an operator's license renewal unless they receive a well inventory?
The way that I'm reading it is the inventory needs to be received before a license is issued or renewed. But again, this document is new today, so didn't have time to review it.
And so it'd be fair to say that whether the regulations required an operator to submit a well inventory or not, staff required one to be submitted before they processed a license renewal application.
I'm not the license department, so how they process their license renewals is not to my knowledge, but yeah, all operators did submit well inventory certifications, yes.
So you're saying that operators have to submit a well inventory certification in order to receive an operator's license? Is that I didn't track the end of your answer. I'm sorry. I'm not trying to ask a new question. I'm just
So an operator is required to submit their well inventory certification every year, yes. And how the license is processed after that or through the processes, that's the licensing department. That's not me. So I don't know.
no further questions.
All right. Any redirect necessary, Mr. Kimbrell?
Sorry, yeah, just one question. Mr. Stoll, are you aware of BG5 ever claiming that they did not have to submit a well inventory or objecting in any way to having to submit a well inventory?
I have not.
Oh, thank you.
All right. I think we've gotten all we can out of this witness. At this time, Mr. Stoll, we thank you for your testimony. You may step down virtually.
Thank you.
Staff, you may call your next witness.
Thank you. Staff calls Ryan Dooling.
All right. Good afternoon, Mr. Dooling.
Good afternoon.
If you would please raise your right hand for me. Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed, Mr. Kimbrell.
Thank you. Mr. Dooling, could you please state your full name for the record?
Ryan Dooling.
Are you the same Ryan Dooling who caused to be filed in this docket direct testimony consisting of 6 pages?
I am.
Do you swear that the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes, sir.
At this time, I would move for the admission of Ryan Dooling's pre-filed direct testimony to the formal record.
No objections.
All right. Hearing no objection, the reference testimony will be admitted.
Thank you. I tender the witness for cross-examination.
Mr. Brock, do you have any cross-examination for this witness?
Very few. Two questions, hopefully. Mr. Dooling, in your pre-filed testimony, you talk about basically an obligation to file a temporary abandonment application. Can you tell me who is required to file that application?
Yeah, could you lead me to where that's at in my testimony real quick, please, Mr. Brock?
Let me get your testimony up. I did not make a note of that one. It's just kind of, you testified generally about temporary abandonment TA applications. So like I'm seeing it starting on page, well, you're talking about the whole, starting at page 4, it's definitely there, but I mean, most of your testimony talks about a TA application.
Correct.
So who is required to file a TA application? And I'll just shortcut it. It doesn't have to be a question. Is it the operator?
Yes, it is. The operator is required to file a TA application.
And so if BG5 was not the operator of these wells, it wouldn't be required to file any kind of temporary abandonment application. Is that correct?
Correct.
Okay. In your testimony, and this is just said twice, this is page 5, line 22 through page 6, line 2. And these are very short statements. You basically just say that since the wells that are at issue in this docket are on BG5's inventory, the only way that BG5 wouldn't be responsible is if they transferred those wells. Is an accurate representation of what you said there?
Yeah, I mean, obviously they could plug them too, but to get them off their inventory, they would have to transfer them to another current active operator.
And is that just your opinion and understanding of the law, or do you have some specific statute or regulation that you believe says that?
I would turn to my legal staff on that question.
Okay. And so I guess if your understanding of the law were incorrect, then that opinion might be incorrect as well. Would that be fair?
Could you repeat that?
So as I understand it in that statement, you're just expressing your understanding of what the law is. And so I'm asking if that understanding were incorrect, then your conclusion that the only way they could not be responsible if it's on their well inventory would also be incorrect, or could also be incorrect.
Could, yes.
No further questions.
All right, we will move to commissioner questions. Commissioner Keither, any questions? I'm seeing a no, and I do not have any questions for you, Mr. Dooling. Any need for redirect?
No,
All right.
thank you.
No redirect. So we will conclude Mr. Dooling's testimony. We thank you for your testimony today, Mr. Dooling. You may virtually step down.
Thank you, sir.
Staff, you may call your final witness.
Thanks. Staff calls Troy Russell.
Good afternoon, Mr. Russell.
Good afternoon, Chair French.
We'll have you please raise your right hand as well. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes,
Okay. Thank you, Mr. Kimbrell. You may proceed.
Thank you. Mr. Russell, could you please state your full name for the record?
Troy Russell.
Are you the same Troy Russell who caused to be filed in this docket direct testimony consisting of 4 pages and rebuttal testimony consisting of 4 pages and 2 exhibits?
Yes,
Do you swear that the answers contained in your pre-filed testimonies were and are true to the best of your knowledge?
yes,
At this time, I move for the admission of Troy Russell's pre-filed direct testimony and pre-filed rebuttal testimony and attached exhibits to the formal record.
No objections.
All right, the reference testimony will be admitted.
I attend to the witness for cross-examination.
All right, Mr. Brock, do you have cross-examination?
Just a few. Mr. Russell, I'm looking at your rebuttal testimony. It would be pages. I forgot to tell you, good afternoon. Good afternoon, Mr. Russell. It would be page 2, line 13 through 15 in your rebuttal. And then it's also on page 3, line 3. And it's more of a general question. I'm only referring to that so you know I'm not trying to trick you. But as I understand it, you're basically saying that the operator should have initiated a show cause proceeding if they thought that was how the matter should have come before the commission. Is that accurate?
that is my understanding, from what our discussions with legal staff is that would have been the way to have brought this to before the commission in a non-penalty manner.
I'm going to share my screen with you real quick, Mr. Russell. So what I'm displaying to you is just KSA 55-179. And so this is the regulation that deals with well responsibility and also show cause proceedings. And so I've just highlighted in the statute, in essence, who has the authority to initiate a show cause proceeding. And it appears to me that the commission is the only party that has the ability to cause people to come before it to show cause as to well responsibility. Do you agree with that statement?
Yeah, it says for an abandoned well, which at this time, none of these are considered abandoned.
I have a question about that. I'll get there in 1 second. But I
Okay.
guess I'm just say with this language, would you agree that it's the commission that would have to initiate it as a show cause proceeding?
Yeah, if we thought it was an abandoned well, yes.
Okay. Um, I guess since you brought it up, I'll go out of order just a touch and I'll ask about your statement. If it was an abandoned well, 55-179 would apply. So it's your contention that this is an abandoned well and that 55-179 doesn't apply. Is that how I understand your testimony?
Yes.
And so on what basis would you contend that BG5 is responsible for these wells?
Well, the definition of abandoned well would be a well that is not on a current active well inventory. And at this time, these wells are. I'm guessing we'll find out soon the answer to that.
I guess maybe I could make the point with an example. If there is a well that's not abandoned, you couldn't just say that I'm responsible. There has to be a basis for it. So what would be the basis that you would claim that BG5 is responsible for these wells if it's not under 55-179?
Well, we would look strongly at the fact that the well inventory had been certified multiple times by the operator.
And so I guess what I'm getting at, is there another regulation, another statute that would impose liability on BG5 for this besides 55-179?
I don't know the specific regs, and I don't know if this is to your question, but I mean, if there are instances if they took written responsibility or had taken some kind of physical control of the well or conducted any type of operations on them.
Yeah. So in this case, would you agree that BG5, the evidence that's presented is that BG5 has not taken physical control or conducted any operations on the wells at issue in this docket?
I have not seen any document showing that that has occurred.
Showing that they have physically operated?
Yeah, I've not seen that
Okay.
any indication that they have operated these wells.
Okay, thank you. One other question: in your rebuttal testimony, you talk about the assignments and the effect of those, and that's on page 3, line 17 of your rebuttal. Trying to get it up for myself. It's where you introduce your exhibits, TR1 and TR2. Are you ready? I'm sorry.
Yeah, I'm looking
Okay.
at your screen share. Yeah.
Okay, I couldn't tell if you were reading it off your screen or if you were waiting for me to ask you another question. So in essence, you're referring to language in the assignment about the assignments of rights, incident thereto, and personal property thereon. Do you know the difference between personal property and real property?
Not in the legal aspect. I mean, the thing I was looking at and had to look up, you know, it is, in our layman terms here, it appears that this was assigned. There was no mention of any wells that I seen. It was just an assignment of this lease and all the, I believe that's what appurtenant applies to. But
Is there anywhere in either of the assignments, the exhibit TR1 or exhibit TR2, that specifically identifies the wells at issue in this docket?
just in a broad sense of the term, I mean, it appears that they assigned everything that was associated with that lease. They did not break them out individually.
Does it even contain language saying that it assigned wells?
Oh, I did not see any language that referenced wells.
And so then certainly there wasn't any reference to these specific wells in this docket, correct?
Not direct reference.
And in those assignments, it talks about assigning ownership and assigning rights. Do you see anywhere in the assignment where it speaks to assigning responsibility for these wells?
Not directly towards these individual wells.
Okay. Thank you very much, Mr. Russell. I don't have any other questions.
All right, we will move to commissioner questions. Commissioner Keither, any questions for Mr. Russell? Seeing a no. I think I have decided I don't have any questions for you, Mr. Russell. I don't see any reason for me to test the legal legal questions I had before, so I think I'll let it go. But I did read all your testimony and appreciate your willingness to be under examination today. Mr. Kimbrell, any redirect?
Just very briefly, Chair. So I'm going to share my screen real fast. So, Mr. Russell, can you see your testimony?
Yes.
And we're looking at the same place that Mr. Brock was talking about earlier. This is page 3 at the top. And in your testimony, you say operator could have filed a motion to open a show cause proceeding. Is that correct?
Yes.
So were you talking here about the operator asking the commission to open a show cause proceeding?
Can you repeat that, Tristan? I'm sorry.
Sure. So Mr. Brock was saying that only the commission can open a show cause proceeding. So were you saying here in your testimony that the commission, that the operator could have asked the commission to open such a show cause proceeding by filing a motion?
I believe they could have.
Okay.
Yes.
And then talking a bit about the assignments. So Mr. Brock said that none of the wells that are at issue in this docket were listed in the assignment. I believe you said that was correct. And I believe you also said that there were no wells listed in those assignments. So I just want to make sure that BG5 did operate some of those wells on the Jackman and Wright lease that were there previously.
Yes.
Okay, I have no further questions.
I don't have any other questions either.
I guess I'm considering asking a commissioner question, which might open up further rounds of examination, but it's on the last point that Mr. Kimbrell just made. I think I'm struggling with this a bit, Mr. Russell, and maybe I should have asked the previous witness, but you're here in front of me now, or 2 witnesses ago. I believe I understand what staff is saying, that, look, there were a couple of leases that were assigned. It looks like there was no breaking out of, such and such wells are being transferred and such aren't. It was all the wells under the leases were assigned. And it looks like the record would indicate that the operator, started operating some of the wells and didn't operate other wells, but basically, chose to operate some and didn't operate others. Would I be correct in understanding that some of the ones that the operator did produce from would have been some of these old wells, and those they've kept on their license, but then some of the ones they didn't operate from are the ones they're excluding from the license now? Don't know that I've asked that the most clear way. I'm just trying to kind of get a layman's understanding of what actually happened here.
Yeah, I think there are
Chair French, I don't mean to interrupt, but I think we may have lost Tristan.
Oh, yes, he looked frozen
Yeah.
and now we've totally lost him. Okay, well, we probably should not proceed without the witnesses' counsel. So let's take a very brief recess. Why don't we just give everybody a brief break? Let's take a 5-minute recess, and then we'll resume at 2:25. Does that work for everybody? All right, very well. We're in recess and off the record, resuming in 5 minutes. All right, we're at 2:25. John, have you heard anything from Tristan? I don't see him.
Yes.
I don't see that he's popped back up here.
Yes, I have heard from him. I was just on the phone with him when you started talking again. His is basically he doesn't know whether it's the internet in the office yet or his computer at the office. It shut down, and when he tries to log in again, it just kind of sits waiting. So I suggested that he go talk to Sean down the hall because we think he's down the hall. I don't know if that will solve the problem. The alternative, I suppose, well, I think Craig's probably at the office too, so we can see whether that's working. I guess we haven't checked on that. Alternatively, Tristan could do this by phone, perhaps, although not ideal. Craig?
Why don't we stand in recess for another 5 minutes? And John, if you are able to get a hold of them, that would be my direction. He can either go sit in with other staff or just have him call on his phone.
Yeah, I'll try to work that out.
Let's actually, should I give you a little more time?
Yeah, probably that would be useful.
All right, let's stand in recess until 2:35 and we'll check back in. I apologize to everyone for the delay. All right, we're off the record, standing in recess.
Craig, are you there? You just went off mute. Are you there?
Yes, Tristan was just down here. So yeah, he's having problems. So I mean, if you guys want him to sit in here, just tell me so. But yeah, he was just here.
Yeah, I think that's probably our simplest path forward, especially since you're done testifying. So if you want to get a hold of Tristan and have him come into your office, I'm sure Chair French doesn't have any problem with spending a few minutes so that he can get set up in there if that's necessary. So if you could track him down and let him know that's probably the best path forward.
Okay, yeah, because my system's working just fine still. So it must be that into the hallway. So I will go get Tristan.
Okay, appreciate it.
Thank you.
Hey, Craig, John Myers here. Have you returned to your office?
Hey, this is Tristan. So yeah, I'm gonna
Just
yeah, I'll
all right.
take steal Craig's computer.
Yeah, that's fine. I'll get your name changed on here. Don't worry about that. Do you have everything in front of you that you theoretically want or that you're
Well,
prepared to go forward with?
I was gonna share my screen when
I
I
see.
press
Are
in. So
those
yeah, it's
are
all
those
the stuff that's filed. So yeah, if you would be willing to,
Yeah,
John.
I'm perfectly able to do that
Yeah.
for you. So just let me know when the time comes. I'll get
Okay.
prepped for that. Let's see here. Also, where we noticed you drop was right when Chair French said he had one question for the witness based upon what you had said. We
Okay.
didn't hear an answer. Chair French is going to have to remember what it is he asked, I think. But that's where we were when we realized it. Is that where you actually dropped off?
Yeah, that's exactly where I dropped off. Yeah.
Okay, excellent. Then I'll get your name changed here. I'll get things pulled up so I can hopefully reasonably quickly pull up things in the document. And then Chair French. Well, I guess we're 2 minutes from 2:35, so we're getting squared away here. You are magically renamed. You are no longer Craig Stoll. Congratulations.
Thank
I
you.
mean, for what it's worth. I mean, the congratulations would go the other way in the other circumstances. So obviously, no offense to your witness.
All right, I've got 2:35, so we are now back on the record, and it does look like we have everybody with us, including Mr. Kimbrell. So we will resume with the examination of Mr. Russell, which I jinxed it by trying to ask one final question here. Let me see if I can recall. I think there was a discussion of what actually happened on the ground with some of these old wells that were transferred under I think it's the Jackman and the Wright leases. And I did find the place in testimony that discusses this. Unfortunately, it wasn't Mr. Stoll's testimony. So, Mr. Russell, if you don't have knowledge of this, you can tell me to take a hike. It's actually at page 5 of Mr. Stoll's rebuttal testimony, and it's at the end, and John can either put it up or I can just describe it. I think essentially what Mr. Stoll said is, look, there were a number of wells that are kind of classified as the old wells under the Wright and Jackman leases, and that's kind of the subset of what operator claims they're not responsible for. But after they were assigned those wells, they did resume production on some of the old wells. I guess I just ask, did you discuss that issue with Mr. Stoll at all?
No.
Okay. Well, then I will reserve any questions about that situation for the operator. So I didn't need to belabor the point, and I jinxed the whole proceeding by doing it, and I apologize. All right. Are there any? I assume that did not trigger the need for any recross or redirect. All right. Okay. Well, then, after sitting through all that, Mr. Russell, you may virtually step down. And I would normally be taking a break here, but we just had a pretty good break. So we'll turn to operator to call your witness.
Yes, we would call Scott Berkdahl.
All right. Good afternoon, Mr. Berkdahl. If you will please, if you're able to go off of mute.
John Myers here. He's working on it. I just I pressed the button to ask him to unmute.
Mr.
Now I've
Chairman,
done it again.
it's okay. I'm going to walk down the hallway and help him.
Chair French, is that fine that
Yeah,
Mr. Brock does that?
let's take a 60-second recess. We're off the record.
I'll be right back.
Can you hear me now?
Yes.
Yes, we hear you.
Okay, I probably evidently pushed the wrong button.
These things happen. All right, we'll wait for your attorney to get back to his chair, and then I'll
Okay.
swear you in. All right, Mr. Brock has returned, so we are now back on the record. Mr. Berkdahl, will you please raise your right hand for me? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, Mr. Brock.
Can you please state your name and business address for the record?
Scott A. Berkdahl. Business address is 3939 Ellis Road, Rantoul, Kansas.
And Mr. Berkdahl, are you the same Scott Berkdahl that caused to be filed pre-filed testimony in this docket consisting of 16 pages and 2 exhibits?
I am.
Do you have any changes or corrections to that testimony?
No.
And if I asked you the same questions today, now that you're under oath, would your answers be the same?
I hope so, yes.
They would?
Yes.
Okay. I would move for the admission of Mr. Berkdahl's pre-filed testimony consisting of 16 pages and 2 exhibits.
All right, any objection?
No objection.
Hearing none, the reference testimony will be admitted.
We tender the witness for cross-examination.
All right, staff, do you have any cross-examination for the witness?
Yes, I do. Thank you. Mr. Berkdahl, just I guess as a bit of background, approximately how many wells does BG5 have on its license?
If I remember correctly, it's like 945.
Okay. And I guess roughly how many of those are actively producing oil or gas at the moment?
That I couldn't answer. I couldn't answer with accuracy
Okay.
today.
Do you know roughly how many you've listed in as producing in Kohler?
No, I don't.
Okay. All right. Mr. Myers, if we could go to Craig Stoll's direct testimony, exhibit KS2, page 1. So that's page 8 of the PDF.
Yes, one moment. I just closed that.
Yeah, right there. Thank you. So Mr. Berkdahl, at the top of this page, it says operator well inventory, right?
Yes.
And this page lists 4 Betts wells and a Williams well. Am I reading that correctly?
Yes.
And approximately when was this page altered, changed, I guess. When was it typed up, I should say?
When was it? What typed up?
Yeah.
Well, the date on it is 6/28/2010.
All right. So roughly 2010.
Yeah.
And did you type in the well information there?
I assume so, yes.
Okay. These wells were BG5's responsibility when you typed them out to the page. Is that correct?
Yes, I think so.
And are they still on BG5's well inventory?
Yes,
Okay. And just to make certain, that's your signature at the bottom of the page there?
it's my initials, yes.
Okay. And you mailed this form to the KCC in 2010. Is that correct?
Here, so yes.
Okay. Mr. Mars, if we could go down to Exhibit KS2, page 10. So that would be page 17 of the PDF. Thank you. So, Mr. Bergdahl, at the top of this page, it still says operator well inventory, correct?
Yes.
And did you type in all of these Jackman wells on this page?
That is in red does not look like my handwriting.
Okay. Everything that's not in red, though, did you type that in?
I think so, yes.
Okay. And that's still your signatures down there at the bottom?
My initials, yes.
Sorry, initials, yes. And you mailed this page to the KCC in 2010?
Yeah.
Okay. So all the other Jackman wells that are at issue in this docket, you also typed them onto the operator well inventory in 2010, is that correct?
Yes, it has the section, township, range, and GPS locations, yes.
Okay. And you put your you put your initials at the bottom of each page, is that
Yes.
correct? And
Yes.
then you made the KCC in 2010.
Yes.
Okay. Mr. Mars, if we could go down to Exhibit KS2, page 33, so that's page 40 of the PDF. Thank you. And so, not to belabor the point, but again, at the top it says operator well inventory, correct?
Yes.
And who typed the right wells onto this page?
There again, that is red is not me,
Okay.
and that is typed in would be.
So everything typed in is what you typed onto this page?
Yes.
Okay. And then, do you remember when you mailed this to the KCC?
There's a date on it, said July 10th, 2011.
Okay. Okay, Mr. Mars, if we could go to Mr. Bergdahl's testimony, Exhibit SB1, so that's page 18 of the PDF.
Yes, one moment.
Yeah, thank
Did
you.
you say? Yeah, sure.
Yeah, page 18, yeah. So Mr. Bergdahl, is this a copy of the letter that you mailed to the KCC along with your well inventory in 2010?
Yes, I think so, yes.
And if we could concentrate on paragraph 3, Mr. Myers. So in paragraph 3, you refer to the Jackson lease. Was that a reference to the Jackman lease?
Yes.
So you wrote there in paragraph 3 that the Jackman lease contains several very old wells. How did you find the wells?
Found the wells when I was doing field research and trying to find an area in the lease that I could drill wells, drill some exploratory wells to determine what the potential reserves left in the lease were. And years before we got acquired the lease, that whole entire section was grown up in heavy brush. And then prior to us getting the lease, the landowners had cleared a lot of the brush and was doing prescribed burning, and it allowed me to better look over the property. And I then discovered these old wells that hadn't been known of before.
Okay.
By
And
me or the KCC.
thank you. And so then you wrote in the letter in paragraph 3 that you put JK next to the old Jackman lease wells that you ended up producing oil from. Is that correct?
Yes, those that were designated as JK weren't necessarily all the old wells. They were wells that I didn't have. Some of them were old wells, and some of them, as it turns out, were duplicates of wells that had had numbers on the wells and stuff that were actually duplicated.
Okay. Of the old wells that you found, approximately how many did you end up producing from?
You know, I don't recall on the JKs how many there were, but there were several.
Several. All right. How did you determine that those wells were viable producers?
I didn't have them predetermined that they were, but they were. Criteria was those wells with the JK. They may have been located close to a flow line, electric lines that we could test pump those to see what they would do.
So you tested the wells to make sure that they were viable, that they were potentially viable wells. Is that what you're saying?
Potentially, yeah.
Yeah. And how did you what did you say you test pump them?
Yeah, we pumped them for a while to find out what they would do and see what we could learn from them, as opposed to oil was whatever $115 a barrel, and it was certainly going to be cheaper to see what we could learn from some of them old wells than to drill wells.
Okay. And did you find some of them, oh, that's not going to be a viable one, so you took out the pump? And
as far as I remember, I'm not sure there was any of those old wells were viable.
Oh, but I thought you said you produced from some of them.
Well, we did produce from some of them. That's the reason that I realized that if I run pumps down them and produced them, then they were going to be my responsibility. And that's the reason I put the JKs as indicating that they had jacks on them and that I had indeed tried to produce.
Okay. So when you wrote in the letter, I'm sorry, Mr. Myers, we could bring that letter back.
Are you seeing the letter, Mr. Kimbrell?
No, I'm not. I'm seeing a
Oh,
regulation.
you're seeing the regulations. Yeah, hold on.
Okay. So going back to paragraph 3, so I believe you wrote in there that the wells that you produced or tried to produce from had JK next to them. So are you saying that you didn't end up producing from any of the wells?
Yeah, I didn't.
I thought you said that you didn't produce from any of the wells, but here in this paragraph, it says that you produced from some of these JK wells. Is that correct?
No, on the JK wells, I attempted to produce on all of them, the ones that were JK wells.
And did you end up producing from some of them?
They produced some oil, but not, as I remember, I don't know as any of them were particularly viable.
Okay. And so there are 54 wells on the Jackman lease that you're arguing that you're not responsible for, correct?
That's correct.
And did you check any of those wells to see if they might be viable producers?
No.
Okay. If we could go to Mr. Bergdahl's testimony exhibit SB1, that's page 19. Yeah, go back up. Yeah, there we go. So you wrote in paragraph 4 of the letter that you followed the same process for the right wells, for the right lease. Is that correct?
Yes.
Okay. So looking over this entire letter, you didn't write anywhere that BG5 was not responsible for the Jackman or Wright wells at issue in this docket, correct?
Well, as I filled out along with Mrs. Raines, Jolene Raines, along with her help, tell me your question again, right?
Sure. So just looking at the letter,
Okay.
you didn't put anywhere in the letter that you're not responsible for certain Jackman and Wright wells, correct?
No, because what I started to say is with me and Mrs. Raines' communications earlier this, it was understood that by not filling in the date that I assumed responsibility, that was understood in this letter.
Yeah.
That
Sorry, go ahead.
that would indicate that I was not claiming responsibility for those ROW wells.
Okay. Out of curiosity, Mr. Berkdahl, do you own the land where the Jackman wells are located?
No,
Who does own it?
my nephews currently own it.
Are they part of the L. Trent Berkdahl Trust?
Yes, I think so.
And are you part of that trust as well?
No,
Okay. So if the state ends up plugging the wells on the Jackman lease, that's going to increase the value of the land, right?
I have no idea knowing whether it increased the value of the land or not.
You don't think getting rid of abandoned wells? You don't think getting rid of old wells, plugging them off, would not increase the value of the land?
I've got an opinion that it probably would, but I don't know that. It certainly wouldn't have any bearing on me.
It would help your nephews, though, right? It would increase the value of their land.
Possibly.
Okay. Mr. Mars, if we could go to Mr. Berkdahl's testimony, Exhibit SB2, page 122 of the PDF. And Mr. Berkdahl, is this a copy of a letter that your attorney sent to the KCC on behalf of BG5 in 2016?
Yeah.
Okay. And was this letter sent because BG5 had received a notice of violation letter from staff regarding the Jackman and Wright wells?
Yes.
At any point in this letter, does it state that BG5 is not responsible for the Jackman and Wright wells?
Not that I can see.
All right, thank you. You can stop the screen share now, Mr. Myers. A couple more questions. So, Mr. Berkdahl, BG5 certified its well inventory through Kohler in 2012. Is that correct?
I think so, yes.
And when certifying the inventory that year in 2012, did BG5 write any notes in Kohler indicating that it wasn't responsible for certain Jackman and Wright wells?
If I remember right, Leslie Town of Drill Baby Drill was doing our inventory, and she informed me that she didn't have the ability through Kohler to put any notes in there saying that we weren't responsible for those subject wells.
Okay. And just to be certain, Drill Baby Drill was employed by BG5. Is that correct?
Yes.
Okay. Again, at the inventory in Kohler, BG5 certified or Drill Baby Drill certified from 2012 through 2020 that the wells were part of BG5's well inventory. Is that correct?
Yeah, noting that the year that we resumed responsibility was not filled in or should not have been.
Were any notes put in Kohler in 2012 through 2020 regarding that?
I don't think that she was able to put any notes in, as I understand it.
All right. At this time, I have no further questions. Thank you.
All right. Are there any commissioner questions? Commissioner Keither? Well, I was going to have questions about the your exploration or your production activities related to the batch of older wells, but I believe you clarified that with Mr. Kimbrell, so I don't think any other questions are necessary from me. Mr. Brock, do you have any redirect?
Yeah, I have a few, Mr. Chairman. Mr. Berkdahl, in paragraph 3 of the letter that you were being shown by commission staff, there were references to your assumed responsibility. Why were you drawing attention to that language in that paragraph?
Well, because like I said, when Miss Raines and Miss Montgomery and I had conversation, and the several conversations that spanned maybe months, that I explained to her specifically what the issues were with what we're calling these subject wells. And I was under the understanding that since they existed, that they needed to go on this inventory, and we couldn't decide, and I was claiming no responsibility for them, that I had not produced them. I wasn't the operator of them, how we dealt with them. And like I say, since this spanned over multiple conversations, I assume that she was going back to KCC staff and getting some guidance on how to deal with these wells. Then it was decided, it wasn't decided by me unilaterally, since they existed, that they go on the inventory, and for me not to claim responsibility was to leave that column of that form blank, and I simply put in the only information I knew about them, along with the ROW assignment of a number and the coordinates that I had based on my GPS location. Does that answer your question?
Yes, it does. And based on written materials, presentations, etc., what was your understanding as presented by the KCC in 2010 of what this well inventory requirement was? What was your understanding of what the KCC wanted to accomplish?
Well, and actually, in a few years, probably in like 2008 and 9, I attended meetings with, it may have been East Kansas Oil and Gas annual meetings and stuff like that, where the KCC was asked to speak, and they were dealing with, or attempting to deal with, unknown abandoned wells in eastern Kansas, and they encouraged producers to come forward without fear of retribution, and if they had abandoned oil wells on their leases or properties, then to bring them forward. There again, since we were BG5 was one of the initial companies that had to do this well inventory, it was my understanding from that, and then talking directly to Ms. Raines, that was appropriate to list those on this inventory, but to not claim responsibility for. Did that answer your question?
Yes, it did. Thank you. You were asked some questions about producing from the old wells. In your experience as an operator in eastern Kansas, would you expect in this area to be able to activate a nearly 100-year-old well and have it be a positive cash flow situation?
No, not after my learning experience on this.
And so if you knew that by activating some of these wells, it was very unlikely to be a positive cash flow situation. Why did BG5 put pumps on some of these abandoned wells?
Well, like I explained, part of it was to see what we could learn from them and possibly, and my maybe naivety thinking that they would be viable. But I was trying to learn something from the formation and in an attempt to locate some areas that I might potentially drill and did drill 6 wells successfully.
So, I mean, would it be a fair summary that you considered it a little bit cheaper to take on an abandoned well and learn from it than to drill an exploratory well?
Yes. Knowing
Um,
full well that I was going to take responsibility of that well.
okay. And just to be clear, I think it's clear, but have you ever denied responsibility for those wells?
No.
Staff had presented to you a letter that was written by me in 2016 to the KCC staff about the wells that are at issue in this docket. Do you recall looking at that letter?
Yes.
At the time that this NOV came up, did you know how these wells came to be added to your well inventory?
No.
And did we have to do something to be able to discover how they got added to your inventory in the first place?
Yes.
Do you remember from that time what we did do?
Well, I think we did a Freedom of Information request.
Yeah, did a freedom of open records request to the KCC to
Right.
figure out how and when they got added to your operator's license. Does that seem accurate to you? You were asked some questions about certifying the well inventory in K.A.R, and you had made some references that Drill Baby Drill didn't have the ability to put notes in there. I just want to drill down a little bit on what you mean by that. Are you saying that the system would not allow her to change the well inventory?
That was my understanding, came from her, that the system would allow that.
And was it required that certain forms be submitted in order to remove a well from the well inventory?
Yes.
Like one of those would be a T1, a transfer of operator?
That's correct.
And did the staff tell you that that would be the only way you could get these wells removed from your well inventory?
That's what I understand, yes.
And just to clarify, it's not your argument that you have assigned these wells to someone else. It's your argument that BG5 never was the operator of them. Is that correct?
That is correct.
Okay. And so would it be fair to say that each year BG5 was presented with an option of either not allowing its license to be renewed or clicking the certification button?
That's correct.
Okay. And it was the K.A.R electronic filing system that created that. Is that true?
Yes, true.
I'm sorry, I was going to show you a page and it wasn't in my notes about where it was, so I was trying to find it real quick. Okay, I'm going to share my screen with you real quick. So, Mr. Berkdahl, this is not your pre-filed testimony. This is the pre-filed testimony of Craig Stoll. It's exhibit KS-6, page 2 of 54. Do you recognize that paragraph?
Yes.
What is it?
It's what went along, I think, with our inventory to put KCC on notices. I don't consider that I'm responsible for those wells.
And does it go on to explain why you needed to mail? I mean, I guess I went one step further. Was this submitted with KA.R, or did you have to mail it, or how was this given to the KCC?
Well, I think that was mailed.
Why did you have to mail that to the KCC?
I think it goes back to the fact that the K.A.R wouldn't allow you to do that in that system.
Okay. And when would statements like this have started being sent to the commission?
You know, I'm not positive. It may have been as late as 16. I don't know for sure.
And at some time, did the KA.R system get changed so that there could be a note added to individual wells?
That's my understanding. Yeah.
But it was at some time after you
Yes.
were sending in this. Okay. I have no further questions. I'm going to stop my share.
All right. Are there any commissioner questions? Commissioner Keither? I guess I just have one clarifying question on that last piece. I had seen that language that Mr. Brock just had up basically looked like it was disclaiming any liability associated with a list of wells. Did I hear you say that that language could have been sent? I believe you said 16. That was sent through the mail, you were saying, as early as 2016? What if you could clarify when that language started to be sent to the KCC when you sent in your well inventory?
You know, and I can't give you a date off the top of my head that would be accurate. I was the early years. I was under the assumption that the inventory that was submitted without that date of resumed responsibility meant the same thing as that letter did. And then somebody in the KCC filled in dates, handwritten, in that may have caused some of the confusion.
All right, thank you. I don't believe I have anything else. Mr. Kimbrell, do you have any recross?
Yes, I do. Questions?
I've been pretty liberal with it, so go ahead. I'll allow it.
Thank you. Mr. Bergdahl, you said that you had multiple conversations with Janelle Raines and Barbara Montgomery. Do you have any documentation of those conversations?
You know, I don't. The only one, I think her and I talked, or not talked, we probably talked, and she had emailed me, I think. It would have been in like May of 2011, and I think it was over some issue with the T1s on the right. But I don't have documentation on how many times or when we talked prior to that letter of the June 29th, 8th or 9th of 2010. But that process that we went through, and I commend both of those ladies for their patience with me, and they admitted that this was also completely new to them. But what I'm getting at, that this wasn't a conversation or two, it was several conversations, because they wasn't quite sure how to, evidently they didn't know exactly the procedures and stuff to fill out some of that stuff, and certainly with the subject to it.
But we have to rely on your memory of these conversations because you don't have any documentation of them. Is that correct?
That's true.
Okay.
Yeah.
You mentioned that you tried to activate the old Jackman wells because it was a learning experience. So in 2010, were you still trying to? Was that still part of your learning experience in 2010?
You know, I can't recall. I think we started doing it. I drilled the 6 wells I think in 2003 and 4. So we would have started some of those wells, obviously prior to that. And I can't tell you exactly when we started them or when we shut them down.
You mentioned that the 2016 letter from Mr. Brock, you were trying to figure out what happened with these Jackman and Wright wells. In 2017, when you renewed your license, you still certified the well inventory in Kohler. Is that correct?
I think so.
Okay. And you mentioned that it was impossible to remove wells from an inventory before certifying. Did you try to do that, you personally?
Not me personally, that Leslie with Drill Baby Drill, I assume had attempted to.
You assume you don't know if she tried to or not.
No, I don't know.
Did you direct her to remove those wells from Kohler?
Yeah, well, it was my understanding. This is where the confusion is. I don't know how you remove those wells. They exist in the field. My whole contention was I didn't operate them. I wasn't responsible for them, but they existed.
Between 2011 and 2020, did you ever give anyone in KCC a call, say, hey, how do I remove these from my inventory?
No,
I think
didn't know it was necessary.
All right. I think you also mentioned that you couldn't put in notes before 2021. Did you personally, in Kohler, saying that you weren't responsible for the wells, did you personally try to put notes into Kohler between 2012 and 2020?
Me personally, no.
Was it Drill Baby Drill who was certifying the inventory?
Yes.
And did you direct Leslie Baker to put notes in?
Yes.
And what
Or
did she report back to you? What did she tell you?
You know, I can't remember what she did respond.
So you don't know for certain whether it was it possible or not because you never followed up.
Right. I'm just going on what she had said.
All right, but you said you couldn't remember what she said.
What? No. Yes. On what dates?
2012 through 2020. You didn't add any notes to Kohler saying that you weren't responsible for the wells. And you said that you did not direct Drill Baby Drill to add notes, or at the very least, you couldn't remember what Leslie Baker told you. Is that correct?
Yes.
Okay. And okay, I think that's the end of my questions. Thank you.
All right. Mr. Brock, any redirect?
I don't think I need to. You've indulged me enough. I appreciate it.
All right. Thank you very much. With that, I think we have concluded with Mr. Bergdahl. Mr. Bergdahl, we thank you for your testimony, and you may virtually step down. And if you're able to just put yourself back on mute, if you can find the button that Mr. Brock found for you. There you go. Thank you very much. All right. Let me see where we're at in our schedule here. Before we move to closing statements, I just want to confirm, it's my understanding the parties did not plan to file legal briefs following this hearing. Is that still correct?
I don't think they're necessary.
I thought we had agreed to consolidate the closing statement into the legal briefs.
Oh, I didn't realize that was your understanding. No, I didn't realize that that was what you had discussed. I think it would make sense to go ahead and have the closing statements, and then do you feel the need for briefs?
Yep. Just for my clarity, Mr. Brock, are you requesting an opportunity to file a legal brief?
I think it would be helpful. I think these are real legal issues. I mean, I've tried to go through some of it with the witnesses, but I mean, they are legal questions, and I recognize that. It seems like it would be helpful to lay that out in an orderly fashion.
Well, I will not deny the parties the opportunity to file a legal brief if they wish to do so. Let's see, 2 weeks is not a very fun amount of time if given the next 2 weeks or the holidays. Why don't the parties get with Mr. Myers before the end of this week? Mr. Myers, can you reach out to them and just schedule a deadline for perhaps just a single simultaneous brief? Although I don't think the commission's going to object to whatever the parties agree on, but I think something brief would be good in this
Yeah,
case. Mr. Myers, is that okay?
I can reach out to them. Yes.
And can you document that through a pre-hearing officer order?
Absolutely. Yeah.
Okay, I think I heard an absolutely. Okay, given the fact that we are going to probably have legal briefing, and my only direction to you all would be let's push it back a little bit so that we're not taking up everybody's holidays. Given the fact that we're going to do that, do the parties still wish to make closing statements? Mr. Kimbrell, it sounded like you were ready, but if you're going to have to do a legal brief, would you like to forgo the closing statement?
Yeah, I'd be willing to waive closing. Thanks.
Okay. And Mr. Brock, that works. It sounds like that was your understanding anyway.
Yeah, I had not prepared one.
Okay, very well. Then I'm glad I asked that. We will move past the closing statements. Mr. Myers will reach out to the parties this week to set up a briefing schedule, and he will memorialize that in an order, shortly thereafter. So with that, are there any other post-hearing issues that the parties need to take up? Oh, I apologize. I do have one additional. I believe we admitted 2 exhibits, Mr. Brock, and we labeled them BG5 Hearing Exhibit 1 and Hearing Exhibit 2. Would you be willing to file those into the docket of this proceeding following today's hearing?
Yeah, I can do that. Do you need me to put like stickers on them, or do they just have it?
If you would label them as BG5 Hearing Exhibit 1 and BG5 Hearing Exhibit 2, I think that would be helpful since that's how they'll be referenced in the transcript.
We'll do.
And there was another document that I believe it may have been one of those that we marked as BG2. It was a license application.
So I had that we marked Exhibit 1 as the license application and Exhibit 2 as the frequently asked questions. I referred to a newspaper article, but ultimately decided not to push my luck by asking.
Yeah, that one didn't make it in. The license application, I believe my ruling was that we had not admitted it yet, but that if you and staff could come to an agreement or confirm that it's within the commission's files and records, then we would admit that in our final order.
And Chair French, I did get an email from the licensing department. They did say that it would be in our records. That is probably in the salt mines.
Well, then I'm going to go ahead and admit BG5 Hearing Exhibit 1. Thank you, Mr. Kimbrell. So both of those will be admitted. Mr. Brock, for clarity of the record, I'd like them filed in the docket.
Will do.
All right. Any other post-hearing matters from the parties? All right. Hearing none, thank you everyone for your time today. This does conclude our hearing, and we will close the record, and we are adjourned. Thank you all. Take care.